One of the most important cases for us at this stage is another Lord Denning judgment. I'm hoping you remember the name of Lord Denning from the lecture on the doctrine of precedent. But the passage I want to draw our attention to now is Lord Denning in a different setting, the famous case, Bulmer and Bollinger. As you might be able to guess from the title of this case, Bulmer and Bollinger. Bulmer makes cider, Bollinger makes champagne. It's an early European EEC case, European Union case, about essentially, I can't go into the details, about intellectual property, about how one markets champagne and how one markets cider, and the kind of claims that you can make about these drinks. The point that we're concerned with, though, relates entirely to how the relevant law is to be interpreted. And I want to focus on the following passage from Lord Denning in Bulmer and Bollinger. So here's a quote. No longer must they, the judges, examine the words in meticulous detail. No longer must they argue about the precise grammatical sense. They must look to purpose or intent. To quote the words of the European Court in the Da Costa case, they must deduce from the wording and the spirit of the treaty the meaning of community rules. They must divine the spirit of the treaty and gain inspiration from it. If they fill a gap, they must fill it as best they can. They must do what the framers of the instrument would have done if they had thought about it. So we must do the same. That last bit, so we must do the same, is clearly a reference to lawyers in the United Kingdom. Lawyers in the United Kingdom, in interpreting community law, have to make use of the techniques that belong to community law, the law of the European Union. Now, to go back to Lord Denning's words, he's stressing the ruling of the European Court of Justice in a case called Da Costa, where, and in Lord Denning's summary, he says that judges or interpreters of European law must deduce from the wording and spirit of the treaty the meaning of community rules. They must divine the spirit of the treaty and gain inspiration from it. Here's the important bit. They fill a gap, they must fill it as they can. They must do what the framers of the instrument would have done if they had thought about it. Now, what is Lord Denning saying here? Let's just think about this sentence. I think it cuts to the chase. They must do what the framers of the instrument would have done if they'd thought about it. Now, in other words, what the judge is being asked to do is almost to imagine that they are a framer of the relevant community rule, and imagine that if they are a framer, how they would have dealt with the gap or the silence or the ambiguity in the law that they're trying to resolve. Now, this is a long way from literal interpretation, which doesn't involve any questions of the ultimate purpose of the legislation. Its focus is narrowly on the wording of the Act itself. So it's as if what we have here is a complete volte-face. It's a complete change of direction in how statute is to be interpreted. The interpreter must divine the spirit of the treaty and gain inspiration from it. Use this understanding to fill the gaps, to resolve the ambiguities that are present within the ambiguous rules. Now, Lord Denning returns to this point in a later case called McCarthy's and Smith, which I think is useful for us at this point in time because it adds a little bit more detail to how this method of interpretation works, and more specifically, how it interfaces with judicial interpretation of UK legislation. Remember what in that little fragment from Lord Denning that we've just been thinking about, he's talking primarily about the community legislation, community rules, the rules of the European Union, European community. We're now we're switching to the related concern of how in those areas where community law and UK law, British law, is how in those areas where EU law is impacting on British law, how a judge must interpret the relative, the important provisions. So this is Lord Denning again, in this case McCarthy's and Smith. Quote, it is important now to declare, and it must be made plain, that the provisions of Article 119 of the Treaty of Rome take priority over anything in our English statute on equal pay, which is inconsistent with Article 119. That priority is given by our own law. It is given by the European Communities Act of 1972 itself. Community law is now part of our law, and wherever there is any inconsistency, community law has priority. It is not supplanting English law, it is part of our law, which overrides any other part which might be inconsistent with it. So let's think about the key issues that lie behind Lord Denning's argument in this case. He starts out by focusing on the provisions of Article 119 of the Treaty of Rome. That's one of the foundational treaties that sets up the EC, or the European Union. And the point that he's making here is that this takes priority over English statute. So the rules, as stated in the Treaty of Rome, will override inconsistent provisions in British statute. Now, it just so happens that McCarthy and Smith concerned equal pay. So the statements on equal pay in community law will override inconsistent provisions in UK law. Now, this obviously takes us back to parliamentary sovereignty. If we're saying that we have to interpret EU law in such a way that it overrides common law, or common law in the sense of the family of common law, or more specifically, it overrides a statute, then what has happened to parliamentary sovereignty? Now, this is a real question, isn't it? However, if one recalls an earlier lecture, this is not perhaps too problematic. The kicker here, the fundamental point, and this is the point that Lord Denning stresses as well, is that this priority, or the priority of European law or over British law, UK law, is given by our own law, i.e. by the law of the United Kingdom. In other words, it is given by the EC Act, the European Communities Act of 1972, which allows Lord Denning to say, community law is now part of our law, and wherever there is an inconsistency, community law has priority. Note, it is not supplanting English law, it is part of our law, which overrides another part which is inconsistent with it. In other words, that takes us back to those arguments about, if you like, the temporary surrender of sovereignty in those areas where community law takes supremacy over UK law. Essentially, it does because Parliament has so provided.